was Prudential Assurance Company and the Commissioners to Her Majesty's Revenue and Customs.
My Lords, in this matter I appear for the Revenue with my learned friends Mr Baldry, Professor Burrows and Miss Bulgrano, and the test claimants are represented by Mr Ernst, Mr Beasley and Mr Bremner, who I believe are all going to address your Lordships later on, or tomorrow.
Yes.
To begin with, my Lord, this is, you will have seen, the latest instalment in a saga which has been running in a number of group litigation orders and other related cases for quite a number of years. These claims were first made in 2003, as were the original claims in FII. And as you will see, you understand, we began in 2003 with pretty much a clean slate. Nobody knew what European law was going to be, or indeed some aspects of the law of the domestic law of restitution, etc. We've now come quite a long way. I was proposing to structure my submissions in the following way. I was going to begin with some introductory comments, which I hope will put everything in context and may remind your Lordships of some matters, which I'm sure you would have in mind in any event. And then I was going to take you to the statutory provisions, in particular the provisions about ACT, which we have to look at. That won't take too long. And then I was proposing to trace, to some extent, the background of the various decisions and to explain and put them in context, in particular leading up to the second reference in FII, which is obviously an important decision in relation to issue 1. And then what I was proposing to do was to deal with issue 1 and the cross appeal, which is issue 4, and then to deal with issue 5, which is also a cross appeal. The reason I'm dealing with them in that order is because I think logically they all go together. They're all part of the process, as I will explain, hopefully, of determining both what was lawful and unlawful under European law and what is taken to have happened in the past. And then I will deal with issue 2, which is the issue about compound interest, and finally issue 3, which is the issue which we require permission. And
is there a, can you just define issue 5, because the respondents relate it to issue 3?
Yes.
Whereas you separate it.
Yes, issue 5, I would submit, is an issue.
Where do we best find it
Probably you can
defined?
Well, there is a statement of facts and issues.
Yes, I've got that.
Perhaps. These were issues that were determined by the Court of Appeal.
Yes, it doesn't really
in this case.
identify issue 5, does it?
It does. Over the page it says, the following issues arise where there's A and B. And what both of those issues are aimed at is to determine where there was an undifferentiated pool of ACT, which was both lawful and unlawful. You require a method of determining whether it was lawful or unlawful ACT, which
yes, I mean,
something happened to.
Is it pro rata or first, so to speak, lawful against lawful, or unlawful against unlawful?
Yes, exactly.
Yeah.
Yes. But what it is, my Lord, I'm going to come back to this in my introductory remarks, but what it is part of the process of determining, in essence, what the facts were or what the facts are treated to have been at the time. Because at the time when all this happened, nobody, of course, was aware that there was unlawful and lawful ACT. Yeah. ACT was a single amorphous mass, and the UK legislation dealt with it as a single mass because there was no reason to differentiate it. But when you come to these claims, it is necessary in a number of cases, and I'll take you to others, to decide when you have a pool of ACT which was both lawful and unlawfully charged, whether it was the lawful ACT or the unlawful ACT, which was, for instance, set off against corporation tax, because that could make a big difference to to the claims. So there has to be a way of determining that, because there is a different treatment depending on whether it's lawful or unlawful ACT. So I'll take you to what Mr. Justice Henderson said about this, because he explained in a couple of paragraphs this process.
Issue 5
that's what issue 5 is about, we say.
Basically A and B, is it?
A and B, yes.
Yes.
There was a third issue in the Court of Appeal, but there's been no appeal against that decision. So it's only 2 of the 3 issues that were dealt with by the Court of Appeal. And the revenue's position in all of these, and you'll see the same comes when we look at FII and other contexts, is that it should be dealt with on a pro rata basis. There's no other sensible basis to deal with it. So can I begin then by a few remarks? The first is maybe obvious, but it's important to keep in mind that the trial from which this is an appeal only concerned the test claimant's claims in unjust enrichment for restitution. It has claims for damages, but it was agreed before the trial that those would not be dealt with at that trial, so they're standing over.
Can I just ask, is there going to be a transcript of this hearing or not?
I understood there was going to be, but I don't see anyone.
Well, I think...
Right.
No.
No.
So well, it's helpful to know it just
Yes.
affects the detail of the note you...
I understand, my lord, yes.
Right. So no transcript, thank you. No, I'm not suggesting there should be.
Right. There are some computers with nobody behind them.
No,
There may be a transcript.
we're used to working without it, but
Yes.
It's quite useful to know.
Yes.
Right.
So the
You can
claims...
also actually watch it. You can watch it rather
Yes, understand.
patiently on the screen afterwards.
Transcribe that.
Yes.
So this was a trial in relation to only the claims of unjust enrichment. The damages claims have been stood over. Of course, the damages claims have 2 problems from the test claimant's point of view. One is the limitation period, which is only 6 years. And I'll come back to why that's quite important. And the other is they have to show that there was a sufficiently serious breach of European law before they can mount claims for damages. In the FII litigation, this issue was argued out before Mr. Justice Henderson and the Court of Appeal, and their decisions in both cases was that there was not a sufficiently serious breach, and so there couldn't be claims for damages.
These are Frankovich claims.
Frankovich claims, my lord, exactly. That is one of the issues where a permission application is pending before this court. And again, I'll come back to that. But it is important to keep this in mind. These are not damages claims. And you may have seen Mr. Justice Henderson deciding on a few occasions that the claims the claimants were seeking to make actually sounded in damages rather than in restitution, and therefore he dismissed the claims as restitutionary claims.
Well, on compound interest, and he said that, didn't he? Am I wrong?
Well, he said it in relation to a claim in relation to section 242, for instance. That's one example.
Anyway, I've certainly recall the passage.
Yeah, because the argument was this is a damages claim, the revenue said, not truly a restitutionary claim, and he upheld that.
He said it actually in relation to, I think, setting off ACT, lawful ACT against unlawful corporation tax, didn't he? But be that as it may, we'll come to it.
We'll come back to that one, yes. The second point is that the test claimant, Prudential, has open accounting periods from 1994. In other words, their returns are subject to inquiry still from that year. And this means that their corporation tax claims can be dealt with under the statutory procedure for those years. And that's why at the end of the decision, you may have seen Mr. Justice Henderson discussing a case called Autologic, which was a decision of the House of Lords, which said that if you can bring a statutory claim to recover tax, even tax unlawfully charged under EU law, then you should do that rather than bringing a High Court claim for restitution or damages. So all the corporation tax claims from 1994 are currently stayed. They haven't been dealt with in these proceedings. What has been dealt with are the pre-94 corporation tax claims and the claims in relation to ACT for all years up until 1999, arguably 1998, when ACT was abolished. This is one of the reasons why mistake claims are important in this case, because it's necessary to bring claims in mistake to take you back to before 1994. In fact, to take back to before 1997. The claims were brought in 2003. A 6-year period would go back to 1997, but before that, it's necessary to bring claims in mistake. And just for completeness, the corporation tax position was equalised in 2009. So there was no longer any breach of EU law after that. Virtually all foreign dividends were exempted from UK tax. The third point, my lord, is that Prudential, you'll be aware, is a test claimant for all of the other members of the CFC and dividend GLO. And of course, Prudential is entitled to whatever judgment it's entitled to, and to whatever claims it can validate. But you can separate, in my submission, the resolution of Prudential's claims from the resolution of the common issues of law which arise in the GLO. And it's important, certainly from the point of view of the revenue, and I imagine too from the point of view of the test claimants and the other claimants who are, I would understand, funding this litigation, that you resolve the issues correctly as a matter of principle. In other words, it's not sufficient to say, well, it doesn't really matter in Prudential's case, but when we come to look at, for instance, compound interest, your lordships will have seen that the result for Prudential is very similar, whether it's Section 35A interest or compound interest. But that's not necessarily the case for all the other claimants in the GLO, and that's why we would wish to have these decisions, these issues decided by this court as a matter of principle. So, my next point, the fourth point, is how these cases work. What is the shape of the litigation? And I would submit you can divide it up conveniently into 4 sections. The first is the fundamental questions: what is the breach of EU law? And what therefore is the appropriate conforming interpretation or disapplication of UK law in the light of that? And of course, that's where the various references to the European Code of Justice, the Code of Justice of the European Union, have come in. And that's the issue to which issues 1 and issue 4, the cross appeal, relate. The second aspect of these cases is to determine what are the facts of a particular case. Now, the facts obviously include things like when dividends were paid and from where, when tax was paid. But it also includes facts which have to be determined in retrospect, and this is going back to the point I was making earlier. There has to be a determination of matters which simply didn't exist at the time. You have to determine how mixed funds, which as far as everyone was concerned at the time, and as far as the law was concerned, were a single fund, how they are to be treated. If I can take an example, your lordships will be aware that ACT could be set off against mainstream corporation tax. So you pay ACT, the company pays it in respect of a dividend, and then when it comes to pay mainstream corporation tax, it can set off the ACT it has paid. However, ACT wasn't necessarily set off in the year in which it was paid. Quite often, ACT would be carried forward and set off later. It is necessary, in order to determine the correct amounts of restitution in these cases, to determine when particular amounts of ACT were set off. Because the ACT that was set off would almost inevitably include both lawful and unlawfully charged ACT. So that's an example of a situation that you have to determine. There are numerous other examples. In the FII case, things were even more complicated because ACT could be surrendered to other group companies. And that happened, of course, in relation to BAT, which is a test claimant in FII. So it was necessary then to decide what ACT had been surrendered, and then when that was utilised by the subsidiary company, for instance. So this is all part, I would submit, of determining what the facts were, or what they are to be treated to have been for the purposes of this litigation. And as I said earlier, issue 5 is an aspect of that part. Once you've decided what the facts were, unlawful tax was charged, some tax was paid, some tax was set off. It's then a question of applying the rules, the English domestic law of unjust enrichment to those facts in order to determine what claims can be made. And of course, if we ever come to the question of damages, you would have to apply the rules of damages, causation, its remoteness, etc., to determine what loss has been suffered as a result of these facts. And issues 2 and 3 concern that question. How do the rules of unjust enrichment, what is the domestic law of unjust enrichment, and how does it apply to these circumstances? The final step in the process is I say mechanical. I don't wish to in any way downplay the complexities and difficulties of it, but it involves calculations. There have to be many calculations done afterwards, applying these principles to decide what the answer is in pounds and pence at the end of the day. So that there are computations that have to be done, and there are spreadsheets, etc. And they apply the principles that I've been discussing, the first 3, but the principles that I've set out are not computational principles. These are all legal principles. They're decided by courts. So it's not right, as I think the test claimants suggest, to say that some of these are the principles that I've been discussing in 1 to 3 are actually purely computational principles. They're not. I would like next to take your lordship just briefly to the pleadings, just to show you what this case looked like when it started. These are in the second
What's the
appendix
purpose
volume.
of being told what it looked like when it started?
Well, there is a purpose. A number of times in the case, the test claimants say such and such a point wasn't pleaded. And I just wanted to show you how things stood as regards to pleadings.
I mean, the Court of Appeal were very critical of the pleadings.
They were, my lord, yes, and I think rightly.
Were all things to all men, more or less.
Yes.
Aren't we ultimately going to be just as interested, if not more, in how the matter was argued, what points were actually raised below? Because one of the objections to one of your heads of issue is that it wasn't raised below.
Yes.
That's issue
Well,
3 in particular.
Right, yes, yes. Well, what I was going to show you, my Lord, first briefly was the pleadings, and then what I was going to show you was the skeletons for the trial, which will essentially be, as you will see, show you what the issues were at that stage.
What at a high level of abstraction, apparently. At a high level.
Yes, but anyway, you can see.
Well, let's look at them.
Yeah.
But the other way of dealing with it might be to relate the pleadings to a particular issue when you come to it. But
well,
if you want to do it now.
That may be a problem.
Basis,
I think what I was really going to show you was that you don't really get any help at all from the pleadings on the issues that we're dealing with. It's tab 20.
I think that provides the answer to my question.
Yes. Yes, well, the reason we're looking at them, my Lord, is because it answers a point that's been made by the test claimants.
Okay.
It's tab 20, MS 3914. These are the pleadings that, as they stood, second amended particulars of claim at the time of the trial. These are the particulars of claim. And these were drafted before the second reference in FII. And they weren't amended after that, so that you won't find any mention in these pleadings of a claim based on the foreign nominal rate. I think it's right to say the basis of these pleadings was that foreign dividends, certainly EU dividends, possibly non-EU dividends after 1993, should be treated as exempt from UK tax. And that, we will see when we look at the skeleton, that continued to be the test claimant's primary case up until trial. So, yeah, there's nothing in these pleadings about the foreign nominal rate or why it applies or how it applies, which rate of tax you apply.
So it pursued exemption rather than credit.
They're pursuing exemption because, to be fair, before 2011, before the second reference, nobody had thought of foreign nominal rates as being relevant to any of this. So they're pursuing exemption, yes. And as regards interest, all that you will find, I think, is page MS 3926, which is right at the end. The bottom of page 350 of the bundle. Which is a claim in the prayer for interest. Now, I think, to be fair, we ought to also just look at the document prior to that, which is tab 19, which is the claim form, because the brief details of claim are slightly different in relation to interest. It's paragraph 6, it's on page MS 3913. So they do mention the rules of law and or equity. Whereas in the particular claim it only mentions the rules of equity. But what is quite clear is that there is no detailed pleading of a claim in unjust enrichment in relation to time value periods. And we'll come back to that when we come to the issue as to what exactly the elements of that claim should be. But that is entirely what the pleadings say. The trial was conducted on the basis of, I think as the Court of Appeal recorded, an agreed set of issues, and what was said in the skeletons prior to the trial. And the claimant's skeleton, there is a respondent's bundle, volume B.
This is the bundle that we got a few days ago, is it?
Yes, I think that's right. Yes. It's tab 4 of that bundle. And you can see it begin, this issue begins on MS 4224, but that only has the issue set out. And then 4225, paragraph 52, the claimants submit primarily that the provisions imposing the D5 charge on foreign source dividends should be disapplied in circumstances where it's unlawful. Alternatively, in the alternative, the claimants submit the provisions should be construed as granting a credit for underlying tax at the nominal corporate tax rate of the member state or third country, which the company paying the dividends established.
You're saying that this is the first time that the credit idea comes in?
Well, this is the first case after the second reference in which it was an issue at all.
Yes, but it's in this case, this is the first introduction of that alternative, is it?
Well, it's the first introduction in the court documents. It hasn't been pleaded or anything.
Exactly.
It appears here. No one's taking any. We're not taking any pleading point on this. I'm trying to just be clear, but we're attempting to, if we like, defend against a pleading point that seems to be being taken that we didn't plead to any of this. But there wasn't anything to plead to. Now the revenues case at this stage was that it was as we still maintain, was that there shouldn't be disapplication, there shouldn't be exemption, but there should be a credit for actual tax paid. And then if you look at what they say about conforming interpretation, paragraph 75, this is in relation to ACT. The present litigation concerns ACT paid on the onward distribution by the UK Water's Edge Company of EU or third country source dividend income. Following FI 1 as interpreted by the Court of Appeal, the claimants would be entitled to a credit against their ACT liability for the actual underlying tax paid. Following FI 2, this extends to underlying tax paid further down the route. As you may have seen, that there was an issue in FII 2 also about what we call the corporate roots argument. As discussed above, the claimants were unable to provide underlying tax information for their portfolio dividends, whether at the Water's Edge or further down the route. So,
can we just get clear where the Water's Edge is? The
Water's Edge.
There are two sides of the channel, yes. And the onward distribution by the UK Water's Edge companies.
Yes.
That's the first company which receives a dividend from abroad.
Yes, it's the company on the yes, exactly.
So you could have an EU Water's Edge company, which is the company which remits the dividend to the UK. And
absolutely, yes.
The UK one, yes.
Yes, and of course there would then typically there will be groups below the Water's Edge. And there'll be groups above the Water's Edge in the UK.
Mean, you have feeder companies, which may be, either downwards or onwards.
Well, very often groups will be structured so that they're trading companies are near the bottom of the group, and then they will pass up profits by way of dividend up through various companies, and then the top company will usually be a holding company that will simply be receiving dividends from subsidiaries and then paying them out to the shareholders. That's the way the groups will be. And the intermediate companies will be there for various reasons, perhaps tax and other reasons. But sometimes there can be quite a few intermediate companies between the the trading companies which actually produce the profits and the top
So it
company.
can be fed down a line before it, and at some point it crosses the channel, and then it's distributed here at some point in the UK.
Yes.
Yes, to shareholders.
In FII, we were looking at groups of companies, so 100% generally shareholding. And the group itself would have parts across the channel, if you like, and parts in the UK. What we're looking at in this case is portfolio holdings. So we're looking at investments in groups which have their top company at the water's edge across the channel, if you like, and who then pay dividends on those portfolio holdings to the UK company. And then we see what is now issue 3, discussed at page 4232. Paragraph 82, 83, 84. The issue of whether the claimant had a claim in respect of lawful ACT utilised against unlawful mainstream corporation tax was debated in the Code of Appeal and FII Code of Appeal. The Code of Appeal held that the claimant's restitutionary remedy extended to lawful ACT utilised against unlawful mainstream tax. On the basis ACT is an advance payment of the mainstream charge. HMRC have sought permission to appeal to the Supreme Court. This is one of the issues which the Supreme Court has deferred its decision on whether to give permission to appeal. That deferral continues, as has been continued by this court until, after this decision, I think. And so they say, pending the Supreme Court's future decision whether to give permission to appeal, the court in the present case is bound by the decision of the Court of Appeal, the claimants have a restitutionary remedy. And that's been the position below, both before Mr Justice Henderson and, of course, before the Court of Appeal as well, but they were bound equally by the previous Court of Appeal decision. So that's why this issue, what is now called issue 3, can only arise in this court. It couldn't be argued below.
This is not an issue which is it an issue which was open in the Court of Appeal? In other words, was permission to appeal given to the Court of Appeal given in respect to this issue in this case?
I don't think we went through that process. It simply was assumed that they'd be bound by the decision of the previous Court of Appeal.
So the situation is we have a Court of Appeal judgment where the issue has been debated, and this court at present hasn't decided whether to grant permission to appeal.
Yes, that's right. Yes.
But this court, one of the points made against you, maybe not in this context, that's what I'm testing, is that we don't have jurisdiction to deal with issues except by way of appeal from the Court of Appeal. If the issue hasn't even got to the Court of Appeal, then there's a potential problem. Is that a problem which arises here?
Well,
I mean, the normal way of dealing with the point, if you wanted to challenge it in the Supreme Court and there was binding authority at Court of Appeal level against you, would be to go to the Court of Appeal and say, give us permission, we know we're going to lose, but we want to go to the Supreme Court. Did you do that?
I can't honestly remember exactly what was said before the Court of Appeal on this issue.
Yes,
but what we do have is an appeal against the, if you like, the judgment which this issue relates to, i.e. the amount of tax that has to be repaid. We have an appeal against that. So and that
well, we have to focus a bit more on it.
That would effectively cover that.
I mean, the fact that you need you accept you need permission to appeal, I think, in your written case, so that
Yes, I think.
you can't. It's not sufficient simply to say it's covered by a blanket. You either need permission to appeal or you don't. And in order to know whether you're entitled to permission to appeal, we have to understand a little bit more about how far this issue is open in this case, as opposed to the FII litigation. It may seem technical, but we ought to get it right.
Yeah, sure.
Yeah.
I'll return to that. Yeah. So that is, and then you will see that there was also a question about how interest was payable, which is page 4255. On what basis is interest payable? And the argument there is for compound interest. So that, my lord, is the basis on which the trial was conducted. Those issues were identified. It wasn't conducted on the basis of looking at what the pleadings said. Now, part of that, you'll see, if you turn back, my lord, to MS 4227, paragraph 63. 4227.
4227, yes.
Where this is the test claimant's argument as to why it should be the nominal rate of the Water's Edge company, the foreign Water's Edge company. A construction based on nominal rates applicable to companies lower down the corporate route would require reading in a network of new detailed provisions addressing the patterns of dividend flows likely to exist below the Water's Edge. Just to give a few examples, we necessary to read in provisions determining how the relevant nominal rates are determined, where profits were earned and taxed in one or more countries and then taxed again wholly or in part in another country, where the profits were taxed in the country where they were earned and largely exempted in another state before onward transmission to the UK. This is what I was mentioning earlier, that it's quite common that the dividends received by the holding company, the Water's Edge company, would be exempt in that country from tax. What is often referred to as a participation exemption, which we now have in this country as well, where the profits pass through an offshore mixer. For those and other scenarios, there need to be detailed rules applying specifically how the nominal rates of tax were to be identified, ascertained and apply. In the claimant's submission, such an exercise would go far beyond the permissible remit of the courts in giving effect to an ECJ ruling. It would be grossly unfair, virtually impossible to substantiate their claims. Now, what you may be aware is that exercise precisely has been done in FII. And again, I'll come back to that because Mr. Justice Henderson in FII decided that the appropriate nominal rate to look at was not the rate of the Water's Edge company, but was the rate of the company where the profits were actually generated and tax was actually paid.
Well, there are some findings in this case by him, though, aren't there, as to the feasibility of the Pru doing this exercise. And I won't claim to reproduce precisely his words, but he basically said it would be impractical, didn't he?
We'll look at what the findings were.
We need to look at precisely what he said, but he
said it would be extremely difficult. yes, it couldn't be expected of them.
Yes.
I think the evidence...
Are we bound by the findings in this case? We can't look at some finding in another case, even though it's the same judge.
You're bound by the finding. I quite agree, my lord. All I'm saying is that it's not, to say it's an exercise that goes far beyond the permissible remit of the courts and giving an effect on ECJ ruling is not, it has turned out not to be correct, because both Mr. Justice Henderson and the Court of Appeal have decided that you can and must do that in FII. That's the only point I was making. As regards this case, it's quite correct that he has said that it would not be expected of them. I think when you actually look at the evidence, it wasn't that they did it and found it impossible. It's simply that they didn't do it at all because they thought it would be impossible. But the point on that is very much the point Mr. Justice Henderson himself made, which is European law says that, I'm afraid, that's simply part of the imputation system.
That's life, they say. You
That's
can't
life.
do it. Too bad you ought to have arranged beforehand to that the information would be given you.
Yes.
When it became important.
You can't pull yourself up by your bootstraps and say that the system should be different because we can't operate the system that is approved. And it's been said a number of times by the European Court that the imputation system is perfectly valid, and it requires you to provide evidence of, if it requires you to provide evidence of tax paid or of nominal rates below, then that is part of the system. And that is one of the issues, precisely what the European Court has said, that arises in the cross appeal. But I think it's important to bear in mind that an assumption that the Water's Edge company would actually have paid tax is probably, in a lot of cases, an unrealistic one. And it has to be accepted that by taking the Water's Edge company, that is being taken as a kind of, well, it doesn't accord, we would say, and we'll come back to this, with the reasoning of the European Court in FII number 2 as to why a foreign nominal rate was an appropriate thing to take.
Wasn't appropriate, yeah. Was
appropriate. It doesn't accord with that, because, and again, Mr. Justice Henderson recognised that himself when he came to look at this again in FII, and I'll show you that. But one has to accept that by taking that foreign nominal rate, you're taking a rate that doesn't necessarily have any connection at all with tax that was actually paid or indeed charged. So I don't think I don't say it's necessary for tax to be paid, but at least it has to be charged at a particular rate.
Well, presumably one reason, if you are looking at the tax position of the, let's say, the EU Water's Edge company, and if, as you say, such a company may well not pay tax, then I suppose it might be logical to look at the foreign national rate of tax. Would that be? I mean, if it doesn't actually pay tax, you'd have to find, if you are looking at it, some other tax rate than the actual one. Is that part of the thinking or not?
Well, what Mr. Justice Henderson decided after looking at it in more detail, perhaps in FII, was that what you should be looking at, or what you should be taking out, is a foreign nominal rate underneath of the company which actually was paying tax, and it was necessary to go through quite a complex process.
So what, the two stages in that argument are that, firstly, you're not looking at the Water's Edge company, you're looking at the feeder companies, which are supplying it with dividends, and secondly, are you looking at the actual rate of the feeder companies?
Well, you're looking at we call the nominal rate, but it means the rate, as opposed to the effective rate. Sorry, my lord, there's this distinction between nominal and effective rates. Perhaps. So
you are looking at the FNR.
The FNR is the headline rate of tax in the particular country,
not the effective.
So you look up and see it's 30% or 35% or whatever, but the effective rate, of course, is the is the rate produced by expressing the amount of tax actually paid by the company as a percentage of its accounting profits.
And that's what we ought to be looking at according to your case.
What we ought to be looking at, according to our case on issue 1, is the actual tax. No, the actual tax paid.
Is that
not
different
rates
from the effective rate?
Well, computationally, you can produce the same result. Yes, you can produce the actual tax paid by applying the effective rate to the profits.
Yeah.
Yeah.
They ought to be the same.
They're all part of the same computation, my lord. Yes, exactly. But you end up. But what you're actually giving credit for is the tax paid against tax.
Yes.
And as we said in our response case, what we say about this is you have to decide at this stage whether it is acte claire that the way in which the test claimants and Mr. Justice Henderson decided this is correct. And that they rely on FI number 2. And we say simply, if you look at FI number 2 and understand it, it doesn't support what they say. Whatever the answer is, it's not what the test claimants say it is. I think I can put it this way. It appears that the test claimant's case is that there are two discrete legal issues. One is, do you use a foreign nominal rate or the actual tax paid? A foreign nominal rate, any one. You decide that issue. Then, completely separately, you decide which foreign nominal rate you use. And they say it's only the first of these issues that you can determine, and you have to accept that the foreign nominal rate is the rate of the Water's Edge company. And we say that's an impossible contention, because to understand why it is a foreign nominal rate, you have to understand which foreign nominal rate you're applying. You can't answer that question in the abstract without understanding the reasoning of the Court of Justice in the second reference. The Court of Justice didn't simply say, use a foreign nominal rate, any rate you think appropriate. It came to its conclusion by a series of propositions and reasoning, which we can look at.
Now, this is a point where there is an objection to your raising it, isn't it?
Well, that's what I think is the objection, my lord. I think the objection is, I'm trying to explain.
Yeah.
They say, well, the only issue here is it a foreign nominal rate or the actual tax?
Yeah, quite.
And you cannot consider
you say you can't
which
separate.
rate it is. You just decide it is a rate, and then we know what the rate is because that's been decided elsewhere. And I say, well, it's impossible to do that, because to answer the question, is it the foreign nominal rate or the actual tax paid, you have to understand the reasoning, not just apply a linguistic analysis, but you have to understand the reasoning of the Court of Justice in the second reference. And as I say, that is the conclusion, as we'll see, that Mr. Justice Henderson himself came to when he looked at it again. And we would say correctly. So I was proposing, my lord, to take you now to the statutory provisions. They're in the first authorities bundle. And the corporation tax provisions are, I would submit straightforward. Corporation tax was at the time charged on foreign dividends. That is dividends from non-UK resident companies, whereas dividends from UK resident companies were exempt from tax under what was then Section 208 of ICTA.
So what's the page reference we're on?
So, sorry, before I came to I was just going to say I wasn't going to look at the corporation tax provisions because they're pretty straightforward. We don't need to look at those. But what we will look at are the ACT provisions, which are behind tab 8 of the bundle. Your Lordships, just on a small point, may see reference to D5 tax. The reason for that is that, going back to the income tax system, foreign dividends were charged under Schedule D Case 5, and corporation tax was charged according to income tax principles. So it's always been referred to in shorthand as D5 income. Of course, everything's changed now with a Corporation Tax Acts, which consolidate everything and don't refer to the income tax principles at all. So, tab 8, MS 4446, section 231, where a company resident in the UK makes a qualifying distribution, a person receiving the distribution is another such company, or a person resident in the United Kingdom not being a company, the recipient shall be entitled to a tax credit equal to such proportion of the amount or value of the distribution as corresponds to the rate of advanced corporation tax in force for the financial year in which the distribution is made. So that provides the credit. It provides a credit for both companies and individuals who receive dividends. The individuals receive the credit by way of, at that time, I think, a credit against basic rate income tax, essentially. And it was originally, until I think 1997, a repayable credit. So if you were someone who had no income, for instance,
you got it back, yeah.
You got it back, and similarly exempt pension funds, etc., got it back. Yeah. That's what changed in 1997 with Gordon Brown. So that grants a credit, and ACT, which we'll go on to, was brought in 1972. And the essential rationale of ACT, domestically, if you like, was to fund the tax credits. The problem was that corporation tax was paid a good deal after the dividends would be paid. And in the meantime, the recipients of the dividends could claim the tax credits, and indeed the exempt institutions could claim a payment in cash immediately. You'll be aware, my lords, that quite a large proportion of public companies are owned by the exempt institutions. So the purpose of ACT was to ensure that something was paid at the time the dividend was paid in order to fund the tax credit. And this was all looked at in a case by the House of Lords, in a case called Pirelli, which your lordships may or may not have heard something about, which was part of the ACT litigation. And essentially it was held by the House of Lords that there was an unspoken link between ACT and the tax credit, which meant essentially if you didn't pay ACT, you didn't get the tax credit that the House of Lords held. But ACT, of course, also operates as an advance payment of corporation tax. So if we move on from section 231 to section 238, which is MS 4464. This is part of the system for collecting ACT. Franked investment income, which is FII, means income of a company resident in the UK which consists of a distribution in respect to which the company is entitled to a tax credit. And franked payment means the sum of the amount or value of a qualifying distribution and their proportion or the amount of value as corresponds to the rate of ACT. And we'll see these concepts are then used in determining, when we come to look at how ACT is calculated. But before we get to that, though, in order, section 239, page 4467, subject to section 497, which is not relevant, subsection 2, advanced corporation tax paid by a company and not repaid in respect of any distribution made by it in an accounting period shall be set against its liability to corporation tax on any profits charged to corporation tax for that accounting period, and shall accordingly discharge a corresponding amount of that liability. So that is the set-off provision in relation to ACT. And subsection 4 then tells you that where there's a surplus advanced corporation tax, which is not set off, it's treated as, exactly, it's carried forward, treated as paid in the subsequent period.
But just thinking aloud, the purpose of the tax credit, in principle, is to ensure that the income is only taxed once in the hands of the company, and not, you don't have the same income taxed a second time in the hands of the recipient of a dividend.
That's right. Yes.
And so the ACT is simply affecting the timing of the company's payment of tax on its income, so that there is effectively a cash flow which will finance the tax credits.
That's the broad idea.
Yeah.
Of course, it doesn't in practice always work out like that, because ACT is often not set off against corporation tax. If there is no corporation tax liability, or very small, then ACT becomes surplus and is carried forward.
Yeah.
So, but that your lordship is right. That's conceptually the underpinning of it all. But the problem which was arising in relation to particularly companies who had foreign income was that they didn't have much corporation tax liability on the foreign income because of double tax relief, basically, and they still were paying ACT because they were distributing the foreign income to their shareholders. So they had to pay ACT, but they didn't have a lot of corporation tax to set it against.
How does that work? Because I thought, you distribute dividends, you distribute income out of profits.
Yes, but these were profits which were not being taxed in the UK. So there were profits, but there wasn't a proportionate amount of corporation tax being paid on the profits, mainly because it was covered by double tax relief. So within the UK system, this caused a build-up of ACT. And this was something that was, if you go right back to the white paper, which I'm not proposing to take you to, but the white paper before the introduction of ACT, this was something that was anticipated at the time that might happen.
Can we just give us a reference to that?
I think it is in the bundles, actually. I'm not sure. I'll find out. But it's not particularly relevant to the
No, but it just helps one get the
background. Yes.
background.
So then section 241, this tells you how you calculate ACT. And where a company receives franked investment income, it's not liable to pay advanced corporation tax in respect of qualifying distributions paid by it in that period, unless the amount of the franked payments made by it exceeds the amount of that income. And 2, if in an accounting period there is such an excess, advanced corporation tax is payable on an amount which, when the advanced corporation tax payable is added to it, is equal to the excess. And if it's a surplus of franked investment income, that's also carried forward. So the way it works is that you compare franked investment income coming in and franked payments, that is dividend payments going out, And if the frank payments exceed the franked investment income, you pay ACT on the difference, essentially. So it's not that there is a, although sometimes in a loose way people talk about a credit against ACT, it's not actually how it works. There isn't actually an ACT liability unless the frank payments exceed the franked investment income. And just finally, for completeness, because it's referred to in a number of cases, Section 247 is the group income election. This allows companies within a group to elect that a dividend paid by them is not chargeable to ACT, but then would not be franked investment income.
Sorry, I'm not.
It's on page 4492.
Right. And what's the proposition? This helps you.
Well, this explains also some of the background to some of the cases, because the ACT litigation, for instance, Sempra, was actually all about group income elections. Because what was argued in Hurst and Sempra was there ought to be the possibility of making a group income election even when you pay a dividend to a non-resident company. Now, of course, the result of that would be there would simply be no ACT paid at all anywhere, because the non-resident companies obviously are not liable to ACT. But that's what the European Court held, that it was a breach of the treaty, freedom of establishment, not to allow UK subsidiaries of German, let's say, parent companies to make a group income election with the German parent, so that no ACT was paid. And that led to the unlawful ACT charges in, for instance, Sempra. That was the background to the Sempra case. And this is, of course, part of the system, because it ensures that ACT is only paid at one level within a group. Typically, most cases, it's paid at the top, but in a few cases, it's paid lower down. But it would generally be paid at the top company level. One of the reasons for that is you can only surrender ACT to subsidiaries. You can't surrender ACT upwards in the group. So usually it would be arranged so that all the payments up to the top company were under group income elections. Now we don't have that in Prudential. The structure in Prudential is very simple. There were two companies, I think. The company we're dealing with, claimant, is actually the Water's Edge bottom company. And it did pay a considerable amount of ACT.
I couldn't hear that.
Sorry, it did pay a considerable amount of ACT. But I think that may be because it's an insurance company and there are particular issues with insurance companies. But in the present case, we don't have the complexities of payments through the group. We simply have receipts by the Water's Edge company and then dividends paid by the Water's Edge company on which ACT was paid. So those are the statutory provisions. And so now what I was proposing to take you through, hopefully relatively speedily, is how the case law developed. I noticed in preparing this case that I don't think there is a full chronology anywhere in the papers. And I thought it might be helpful to you, it's certainly helpful to me, to have a chronology. This is simply a chronology of when the various decisions were taken.
I have to say I spent some time writing one out.
So all right.
Certainly be, I hope, confirmatory.
Oh.
But I would quite like it, because I didn't spend some time.
Yes. Well, we have. It's not agreed, but I don't think it's controversial. I mean, it simply states the dates on which decisions were taken.
Yes, it's very, very helpful, and possibly with the references as to where they are as well.
This one doesn't, but I think
Well, don't worry.
we can easily provide that without any.
It's quite, I think your case has at the beginning.
Yes, we have a glossary at the beginning, which I think does that. Sorry. Keep proceeding.
Can I just ask to make sure I'm following this, that the problem is, leaving aside group income elections, which we're not concerned with directly here, the problem is partly the one that you mentioned earlier, that if you're receiving your income from a foreign company, you're unlikely to have much corporation tax to set your ACT against. But also, the income that you're receiving isn't going to be franked investment income, and so you won't get the you'll be paying ACT on the whole of it rather than simply the slice that would be taxable under Section 241 if you were if it were UK dividend income.
Yes,
right.
Yes, that's right, and I'll come on to that. But yes, ACT. There are slightly different issues in ACT, but essentially that's the point, my lord. Yes. So the starting point are two references that were made. The first, chronologically, was a reference in the FII GLO, and that was made on the 13th of October, 2004. And I think we just ought to look at at least the questions that were referred, just to understand the structure of that, because we will have to look at the FII cases. It's in Bundle 7 of the authorities, tab 70, it's MS 2689. So the questions begin at the bottom of MS 2689. And as I mentioned earlier, at this point, when we were agreeing these references, this reference, we really were at the very beginning. We didn't have any clue really what the Court of Justice was going to say and what the shape of the litigation was going to be. But question 1 is a question about corporation tax. It's a basic question, and we'll see that the answer to that question caused a lot of difficulty. But it's essentially asking whether it is contrary to Article 43 to apply measures which exempt from corporation tax dividends received by a resident company, but don't exempt dividends, other dividends, but provide double taxation relief, both for withholding tax in all cases, and in some cases for underlying tax.
When it's talking about exemption, is that the exemption of 10% shareholdings?
That's the exemption is the UK exemption. Mm-hmm. So all UK dividends.
Oh yes, of course.
Are exempt from tax.
Yes,
yeah.
Yes, of course.
And then the second question relates to ACT. And that's the point my Lord Reid was reverting to. That when they receive foreign dividends, they're not in any way FII. Question 3 is a slightly esoteric question, but it's asking, it's pointing out that you can surrender ACT to UK resident companies, which they can set against their corporation tax, but you can't surrender it to non-UK resident companies. And the question was that a breach of the treaty? And we'll see that the court came back with an answer that the test claimants said was not the question that they'd asked. So it had to be, this question also had to be re-referred in the second reference. Question 4 is about FIDs. I'm not going to say anything about FIDs. There's a lot about FIDs in FII, but not in this case. This was a method introduced in 1994 to attempt to ameliorate the problem of surplus ACT. But unless your lordship really want me, I'm going to go into FIDs. Question 5 then was a question about standstill provision. That is a provision which relates to the free movement of capital. And what it says is where you have movements between the UK, or a member state, sorry, and a third country, if there was a restriction in force in at the end of 1993, then you can continue to have that restriction. The background to that was that it was at that date that the free movement of capital provisions were extended to third countries outside the EU. So there is this standstill provision, and questions have arisen in the litigation as to whether there is a new restriction after 1993 when the legislation changes, etc. Now, standstill is not relevant in this case because standstill provisions don't apply to portfolio dividends. They only apply to basically at least, I think, possibly 25% or more holdings. But it's very important in the FII case. And then finally, there was a whole lot of questions referred, you'll see, questions 7, 8 and 9, all about remedies. Essentially asking whether various claims were claims for repayment or were damages claims. And also questions about factor tame, whether there was a sufficiently serious breach, which is question 9. So a whole lot of questions were asked of the European Court. And there was a similar reference made. That was 13th October 2004. A similar reference was made in the present GLO on the 18th of March 2005. And that can be seen in the core volume. So the reference in the present case is in the core volume at tab 10 near the back. It begins on MS 3716. And the questions are on 3721. So again, the first question is a general question about corporation tax. The second question is a particular question relating to corporation tax and insurance companies, which quite a number of the claimants in this GLO were insurance companies. Then question 3 is about something completely different, which is controlled foreign companies legislation, which is why this GLO is called the CFC and dividend GLO, related to two things. We're not at all interested in the CFC provisions. And then there was a question about third countries. Was there any difference if it was for the countries? That's question 4. And a question about standstill provisions again, question 5. And then again 6, 7, 8, 9 and 10, 11 and 12 were all questions about remedies. And the answer came back in FII on the 12th of December 2006. That was when the judgment of the court was delivered that we've been looking at in Bundle 7.
Right, what page again?
Well, we were looking at the judgment. It was tab 70, beginning
Yes.
of 2679. It begins
Yes,
on
I got it,
MS.
yes.
That's the judgment of the court in FII. And it came, the answer to question 1 is one that we have to look at again when we come to FI number 2. Essentially, it sent back a question to the National Court. Which was whether the rates of tax, which it referred to in the judgment, were indeed the same in the UK.
Hey, where was that?
It deals with, sorry, a lot. It begins dealing with question 1 on page 2695, and then it gives its conclusions are on page 2707.
2707.
2707. And probably the best place to find the question is on page 2702, paragraph 56. It's for the National Court to determine whether the tax rates are indeed the same and whether different levels of taxation occur only in certain cases by reason of a change in the tax base as a result of certain exceptional reliefs. So, and that was the question that caused the controversy, because the difficulty when we came back to the High Court was determining what the question meant.
Yes, I mean, what does the question mean? The application to the company making the distribution and the company receiving it. Just fit those into the chain. Which are they?
Sorry, which paragraph are you looking at?
Paragraph 55, the previous paragraph, which leads into 56, doesn't it?
Yes. Well, that was all part of the puzzle in this case. What no one could understand is why the European Court were confused by this point. The different levels of taxation.
The company making the distribution, that's the foreign company, is it? The Foreign Waters Edge company? And the company receiving it?
No. In this, what they're looking at, my lord, this is quite important, what they're focusing on is dividends paid between UK companies.
Yes, I see.
Yeah, so paragraph 54 seems to be the point that they're discussing.
Yeah. So they're asking the question, where a UK company subsidiary pays a dividend to its parent company.
Yes, I see.
Are the rates of tax the same that the subsidiary pays and the parent?
Yes, because if the subsidiary pays an actual rate of tax which is less than the nominal rate, then the exemption is giving something different from what would be given if they were both paying the same nominal rate.
Well, that's the reasoning of the European Court. Yes, yeah. Yes, my lord.
That's what they come to.
That's what they say.
Yeah.
What they seem to be saying is that there won't be equivalent treatment if a UK company subsidiary paying to its parent the dividend's exempt, even though the subsidiary pays tax at a lower effective rate than the nominal rate of tax. Assuming, I think, that the parent will pay tax at the nominal rate, essentially. That's the reasoning. I don't say it's necessarily.
So, I mean, the reasoning.
Sound reasoning, but it is the reasoning.
On the assumption that they are the same, then you can forget about the problem and simply give a credit by way of exemption.
I think what's saying, if they are the same, then there's equivalent treatment, and therefore the yes, it's fine to give credit for actual tax paid. And the difficult question was what was meant by the rates of tax. Because if you read the whole of it, I'm not going to take you through it, but because this is of purely historical interest now. But if you read through the judgment, it's not at all clear whether they're referring to the nominal rates or effective rates. And what happened was there was then an argument in the High Court as to what the question meant, essentially. It was agreed, the answer was agreed. It was simply the question that was the problem. If the question was, were the nominal rates the same, then the answer was clearly they were. Nobody disputed that. If the answer was, is the effective rate paid by the subsidiary less in some cases, more than merely exceptional cases, is it less than the nominal rate? The answer was clearly yes, it was. There's no doubt UK companies have reliefs and exemptions and whatever for tax purposes that are not reflected in the computation of the profits for accounting purposes. So there's no doubt in any developed system of tax that there will be differences between the effective rate for tax purposes and the nominal rate. So that was the question. And Mr. Justice Henderson decided, well, just jumping slightly ahead, he decided when it came back that it meant the effective rate, and therefore he concluded that the UK provisions were unlawful in their entirety, and therefore would be disapplied. So the conclusion that Mr. Justice Henderson came to the first time round was that there should effectively be a complete exemption for EU dividends coming from EU countries. Not for third country dividends, because the standstill provision applied to those, but EU dividends. And that then went to the Court of Appeal, and the Court of Appeal were divided. The majority thought that we were right, that it was referring to nominal rates. The minority thought that Mr. Justice Henderson was right, and the Court of Appeal therefore decided to refer the question back to the Court of Justice. And that's what became the second reference. We'll return to that when we look at the ECJ2. The answer to the second question on ACT, you will find at paragraph 112, MS 2717. And it was Article 43 and 56 precluded legislation which allows a resident company receiving dividends from another resident company to deduct from the amount which the former is liable to pay by way of ACT the amount of tax paid by the latter company, whereas no such deduction is permitted in the case of a resident company receiving dividends from a non-resident company. Now, the comparison there that the European Court was drawing was between a UK company which pays a dividend to its parent without a group income election and therefore pays ACT, and the payment is therefore franked investment income. And the court was regarding that as being essentially a deduction of the tax paid. Now, we've seen that that's not exactly how the system worked, but that's how they conceptualised it. That the parent was able to deduct the ACT that was paid by the subsidiary in computing its ACT liability. But a non-resident subsidiary paying to a UK parent, the UK parent could not deduct any of the tax liability, tax payments by the subsidiary from its ACT. So that's the comparison. The question then arose when the matter went back. It was assumed at that stage that this meant that you had to grant a credit for tax paid, foreign tax paid, against ACT. So that's what it appears to have been saying. But the question was, did it only refer to the tax paid by the top company, the company that was paying the dividend, the Water's Edge company, or did it refer also to tax paid further down the chain? The European Court decision appeared to only refer to the tax company paying. And that was the corporate roots argument, which you'll see referred to. And that was another question Mr. Justice Henderson decided to refer to the European Court as a result of the first hearing. And that was appealed, but all the courts above confirmed that the reference should take place. So there was that was one of the questions that was referred. And as I said, the answer to this in FII came back on the 12th of December 2006. Following that, and another case in relation to CFCs called Cadbury Schweppes, which was a separate case, which also was referred to the European Court, the court then wrote to the parties in the CFC case and asked whether we wanted to maintain the reference.
Whether you wanted to?
Sorry, maintain the reference. And the answer that came back was that we did, or the National Court said it wanted to maintain the reference. And you can see that recorded in the judgment of the court in the CFC case, core volume tab 10. Page 3723. You can see paragraph 33. The referring court informed the court that it was maintaining its reference. And then 34, under the first subparagraph of 104.3, where a question referred to the court for a preliminary ruling is identical to a question on which the court has already ruled, or where the answer to such a question may be clearly deduced from existing case law, the court may, after hearing the Advocate General at any time, give its decision by reasoned order. By hearing the Advocate General, I think they just mean talking to him. So there is no Advocate General opinion in this.
This is the court's attempt to give a stuffy answer to a reference which...
It believes the answer is obvious, yes.
Although it took 132 paragraphs to say it.
To say that, yes. Yes. But this is... It's one of the points that we make, which is it is slightly peculiar that the Court of Justice should have considered the answer could be clearly deduced from the case law in this reference, when according to the test claimant's case, they didn't give the correct answer, or the full answer to the question in this, what they gave here. What the test claimants say is you have to read this as being modified by what they decided subsequently. So essentially what's being said is the answer they gave here, although they thought it was so clear that it could be dealt with without a hearing, without an Advocate General opinion, by a reasoned order, it was so clear it was actually wrong, essentially.
But were the problems of interpretation of the earlier ruling raised with the court in this second reference?
Not that I'm aware of, no.
No. I only ask because there was a gap of about 16 months between the dates of a judgment in the first case and a reasoned order in the second.
Yes, although if we then look at the hearing in the High Court, where it first arose, was actually in July 2008.
Yeah.
So it was after this judgment was given.
I see.
And the answers that were given, as I said, the first question related, was a general question about corporation tax, and the answer they gave repeated pretty much verbatim what was said in the FII reference. You can see by just glancing down that they're referring constantly to.
Which page are we on now?
Sorry, it begins, my lord, at page 3723, the first question, and continues till 3725. And you can note that even in this decision, when it comes to the holding at the end, paragraph 43, which is the answer, there is a distinction drawn between the portfolio holdings, which is the bottom, less than 10% voting rights, and the others above it. And then when we come to the second question, which is specifically about the insurance companies, you'll see that the structure is, again, following to some extent FII. The first issue for them was whether it should be Article 56 or 43, and they decided at paragraph 52 it should be Article 56. And then they consider between paragraphs 53 and 57, they consider the issue of an election that an insurance company could make. And the question was whether that was contrary to Article 56. And paragraph 56, they say, in the regard, it's not apparent from the decision making the reference whether in the light of the fact the permitted election as regards dividends of national origin entailed the waiver of tax credits, a company receiving dividends of foreign origin which could not exercise such an election was treated less favourably because of that fact alone. It's for the National Court to establish whether such was the case. The point there was that the dividends to the insurance company were, in fact, the UK dividends were prima facie taxed, but there was an ability to elect for them to be exempt, which then meant that they didn't receive tax credit that they would otherwise have received. And the question was whether allowing that election to take place was more favourable treatment for UK dividends. And the court said it was send it back to the National Court to determine that. It then says in paragraph 58, it's clear, on the other hand, since it's clear from the decision making the reference that companies with less than 10% shareholding in the company making the distribution were not entitled to relief in respect of corporation tax paid by that company in the member state in which it was resident, those companies were contrary to Article 56, subject to less favourable tax treatment. So they're making the point that there was less favourable treatment simply because of the lack of corporation tax, relief for corporation tax paid abroad. And the UK then were arguing that it was proportionate and legitimate to restrict the availability of relief for various reasons in respect of the difficulties of determining the tax, which is paragraphs 59, 60 and 61. And that was rejected as being a justification for the difference of treatment. And then, beginning at paragraph 64, you can see the UK contends the difference in treatment is justified by the need to ensure the cohesion of the tax system. And that is rejected at paragraphs 67 and 68. And then paragraph 60, the answer to the second question must be Article 56 is to be interpreted as meaning it precludes legislation in a member state which allows an exemption from corporation tax for certain dividends received from resident companies by resident insurance companies, but excludes such an exemption for similar dividends received from non-resident companies, insofar as it entails less favourable treatment of the latter dividends. And the less favourable treatment was obviously, as I've expressed earlier, not granting the credit for corporation tax, foreign corporation tax. And then they go on to consider CFCs, and the third question considers third countries, and then the fourth question considers CFCs, which we're not concerned with. So we would submit all that you can draw from the answer to the reference in the present case is that there is less favourable treatment by not providing a credit in respect of corporation tax paid abroad. And the justification of the need to ensure fiscal cohesion is not available. Now we can perhaps look at chronologically what happened next, which was Mr. Justice Henderson's decision in the High Court, yes. Which is Authorities 5, tab 53. It begins MS 1565. Now, there have been 2 rounds of hearings before Mr. Justice Henderson in the FII case. The first of those was this hearing, and you can see if you turn to page MS 1565, you can see the legal issues that Mr. Justice Henderson had to determine. There are quite a few of them, as you can see. The way this part of the hearing took place, the way it was organised, was to have in this context, fairly skeletal set of facts, which was simply a basis for Mr. Justice Henderson to decide a number of issues of law which clearly were going to arise in general in the GLO. What then happened was, well, there was an appeal on those issues to the Court of Appeal, and then a further appeal, will come back to that, to the Supreme Court. But after that, when we came back to Mr. Justice Henderson the second time, the way it was organised was by an actual trial of the BAT claim, the British American Tobacco claim, which raised a whole lot of other legal issues, but was argued on the basis of the actual facts of that case. So it was, if you like, more like Prudential. But at this stage, it's being argued almost as preliminary points. because clearly a very large number of legal issues still arose which had to be determined. And for these purposes, the main issues of interest are issue 1, the D5, and issues 3, 1 and 2, questions relating to ACT. And also the remedies issue, in particular issue 3, restitution or damages. So what Mr. Justice Henderson decided, as I've already indicated, on issue 1 was that the charge was unlawful in its entirety. Because he decided that what the European Court were referring to was the effective rates, and because the effective rate was not the same as the nominal rate, and that meant that particular let-out didn't apply, and the European Court had not mentioned any other let-outs or qualifications at that stage. We'll see that changes when we come to the second reference, but at that stage they had not said anything further. They had not dealt with the fiscal cohesion argument at all in the first reference. It wasn't even mentioned. Then on the corporate tree points, he decided to refer these questions to the European Court. But he did decide, as a matter of conforming interpretation, that assuming tax was paid abroad, all of the foreign dividends, or the EU dividends, should be treated as FII. So he held it wasn't a question of giving credit for foreign tax or anything like that, that they would simply treat the entire dividend as FII and operate the UK system as if it was FII. And as regards remedies, he decided, the point that's relevant to this case, he decided that various reliefs that were given, where the taxpayer was saying that they'd wasted reliefs because they had set reliefs against what was now known to be unlawfully charged corporation tax, the claimants did not have a restitutionary claim in respect of those, I'm using the word inverted commas, wasted reliefs. That any claim that they did have would be in damages. And that included, at that stage, ACT. So Mr. Justice Henderson held that where ACT was set against unlawful corporation tax, again, there was no claim in restitution.
A relief is not a disbursement. A relief is a loss of an opportunity.
Exactly. Yes, exactly, my lord. So there's no putting it in terms of unjust enrichment. There's no enrichment of the revenue at that point.
Yes.
It is, of course, possible that there may be a knock-on effect. In other words, that the taxpayers would not, if they had known, they wouldn't have used the relief there, they would have used it somewhere else. And therefore, there would be a loss in that sense. But that, he said, was not a claim in unjust enrichment. It was potentially a claim in damages, if you could show that because there'd been an unlawful charge, you had set your relief against the corporation tax, and you would actually have set it against something else, somewhere else, in the group or at some other time, something like that. So that's but that wasn't the claim that was being...
It's too indirect, I suppose. Is that another way of putting it? I mean, it depends on circumstances and perhaps choice.
Exactly. Well, that was, I think, the way Mr. Justice Henderson put it. It was a matter of, and it's the way the European Court had also differentiated between repayment claims and Frankovich claims, the question of whether there was a decision made by the taxpayer. So what the European Court broadly said was, if there's an unlawful charge, you get back all the tax you paid in response to the unlawful charge, and anything connected with that, for instance, interest or penalties that you might have paid. But you don't get back. You're not entitled to back as a repayment claim or restitution things that are more indirect and resulted from exercises of decisions or judgment by the taxpayers. So this was what is part of this was what is now issue 3 here. So that was what Mr. Justice Henderson decided, and then there was an appeal from that to the Court of Appeal, and you can see again, if you turn, this is behind tab 54, begins on MS 1699. And if you turn to 1716, you will see an index of the judgment which sets out all the various issues that were determined. And there were 23, you can see, legal issues had to be determined. So as regards issue 1, as I've already mentioned, the Court of Appeal decided, a majority would have decided the case the other way, but they felt that it was right to refer the matter since there was a disagreement. And they confirmed that the references in relation to the corporate roots points in relation to ACT, as regards the restitutionary...
Sorry, I haven't got that point.
Oh,
you
sorry.
dropped your voice.
I'm sorry. They confirmed... I'm very sorry, my lord. I'm slightly struggling with my throat, so I'll make every effort to speak up, sorry. But they confirmed the corporate roots references that had been made by Mr. Justice Henderson, i.e. in relation to ACT, whether you took account of foreign tax only at the water's edge or whether you took account of it further down as well. They decided that that should be referred. In other words, they dismissed the appeal against the reference.
You said the majority?
No, sorry, it was only the majority on issue 1. On the other issues, they were unanimous. On issue 1, there was a division of opinion as to what the correct answer was.
Where does that appear?
Well,
somewhere.
You can see it from the head note, first of all, on page 1707, where it says held 1, Mr. Lord Justice Etherton dissenting.
That's it. Yes, I see.
And I think you would find it probably, it's just at the end.
Yes, I see. Yes, well, that's identified it.
Yeah. So, yes, Lady Justice Arden and Lord Justice Stanley Burnton agreed one way and Lord Justice Etherton thought the other way. And the reasoning was set out, I think, in an annex to the judgment. Yeah. It's on page 1809, Annex 3, the differing analyses in answer 1 between the majority and the minority. But anyway, again, this is of historical interest only because we now have the European Court decision on this point. So, what the judges thought previously is not really relevant. But then, crucially, on the restitutionary issue, that is issue 13, which begins at paragraph 175, the Court of Appeal The Court of Appeal agreed with with Mr. Justice Henderson in relation to reliefs other than ACT. They agreed that those were not restitutionary claims, but they held that the position was different as regards ACT. And that's the decision that has been binding so far. And they decided it on the basis, I think, the short basis that the European Court regards ACT as being a prepayment of corporation tax. That is conceptually how the European Court has looked at ACT. But of course, as we shall see when we come to this issue, that doesn't answer the question, the restitutionary question in English law, where lawful ACT is set against unlawful corporation tax, whether there's any enrichment of the revenue.
Sorry, in the Court of Appeal here is upholding the judge on this point? It appears, paragraph 179 it is.
It upheld the judge on all the parts apart from ACT.
Apart from
ACT.
ACT, and where is it different?
Well, 179 at the beginning, in our judgment, the only relief capable of being restored as an unjust enrichment is the application of ACT against the Case 5 charge. That is, for the reasons we have given, a San Giorgio claim is regarded as an advance payment of MCT. Utilisation of the other reliefs may have been a detriment to the claimants, but did not represent a gain to the revenue for the purpose of a restitutionary cause of action. And then they go on to deal with...
So that's the one point.
So that's the one point, yes.
Yes, which differs from him. But are they talking about setting it off against unlawful?
Yes,
Case
they're
5.
talking about unlawful Case 5, yeah.
Has to be.
All of this is talking about setting reliefs, etc., against unlawful Case 5. So obviously, if they're set against lawful Case 5, there isn't any problem.
There's no problem at all, right?
Yeah. But we are talking importantly about lawful ACT. That is, having gone through the process of determining which ACT is lawful and which is unlawful, it's been determined that this particular ACT was lawfully charged. So there would be no question of recovering the ACT itself when it was charged, because it was perfectly lawfully charged. The question is whether something happens when it's set off against, or purports to be set off against an unlawful charge to corporation tax. Now, you will have seen that our primary contention about this is that there simply was no set off at that time, because the provision for set off, section 239, only applies where there is a liability to corporation tax. And there was no liability.
You say there can't have been a benefit to the revenue because the ACT remains chargeable. They can still reclaim it against some future corporation tax. This is an ineffective transaction.
That's correct.
Setting it off against an unlawful charge is a nullity.
Yes, yeah. And as we shall see, that is the way that the set-off of ACT against unlawful corporation tax has been treated by the parties and Mr. Justice Henderson in general. That unlawful ACT, that's how unlawful ACT set against unlawful corporation tax has been treated. So the way that that's been treated is the unlawful ACT remains unutilised, because nothing happened, because there was no charge to corporation tax to set it against. So where there's been unlawful ACT charged, even if it's been purported to be set against unlawful CT, it's treated for these purposes as remaining outstanding, so that the taxpayers are able to claim the full amount of the ACT back with interest, not just a SEMPRA amount, that is an amount computed on the basis of set-off. I'll come back to that, but that's an important part of the argument. That is the way that it's been treated, and we'll see Mr. Justice Henderson sets that out in the Prudential judgment itself. Your Lordship is being puzzled.
No, I'm sure there are lots of things that are against.
And can I just ask you, I mean, I have to confess I'm not finding it terribly easy to keep up with all this. Is there any of does the Court of Appeal set all this out with reasonable clarity, or where's the best account of what's been going on?
Well, the problem is that two of these issues were not considered by the Court of Appeal.
I understand that's
for different reasons, well, perhaps for the same reason.
In your case?
Yes, that's right.
Yes,
The only place in which the compound interest point, restitution, has been fully considered is Mr. Justice Henderson's judgment in this case, which he then followed in Littlewoods. So,
yes, but we're going all through this for what purpose? I mean,
well, the reason for going through this,
get to the point and see how it's dealt with for our purposes.
Yes. Well, it's necessary, I think, sorry, my Lord, to understand the background, because when you look at, for instance, the second reference, it isn't very obvious what's being decided unless you understand where it's come from, and why they're deciding those questions. That's the only reason for looking at this.
I thought I understood it from your case. I'm not quite sure whether what's happened this morning has made it clear.
Well, that was wonderful if I could just rely on my case and sit down, it would be fine. The Court of Appeal decision, then there were appeals by both sides from the decisions of the Court of Appeal, or rather applications for permission to this court on virtually all the issues, most of the issues, on both ways. The issue that you have heard, and my Lord Reid and Lord Sumption were involved, I think, you heard some of these appeals, particularly in relation to limitation and whether certain limitation provisions were contrary to EU law. But there were other issues also decided in relation to domestic matters, in particular whether Section 32(1)(a) required that there be a mistake as an element of the cause of action, or whether it was sufficient. Oh, sorry, 1C, 32(1)(c), whether it was sufficient that there was a mistake in the background of the case. And this court decided, confirming a line of authority, that it had to be an element in the cause of action. And this is why, crucially, it's essential for the test claimants and all the claimants in these GLOs to bring their claims within mistake of law. Restitution, that is unjust enrichment on the basis of mistake. And I'll come back to that because that's important in some of the later issues, to focus that these claims are all brought in mistake. So those issues were determined. There was a further reference made by this court in relation to the limitation issues, but I don't think we need to look at that because I don't think it's relevant for the present cases. That's the third reference in FII. Other issues remain outstanding. The court decided to adjourn, I think was the term used, I can't remember, consideration of the permission applications pending all these things coming back from the European Court. We then, I think, went back to the court after the Court of Appeal decision in FII the second time around, making further applications, and the court decided to, again, put it all off until after, first of all, Littlewoods, which this court has heard and decided, but then also this case. So I think the position is that after this case is decided, there will have to be a decision made by this court as to whether or not to grant permission on various issues which remain from the first time round with the Court of Appeal and the second time round with the Court of Appeal in FII. There's quite a lot of issues. Now, some of these issues might be decided by this court now, but there's likely to be some issues still remaining outstanding. But that's where we are procedurally. That's why we're in this kind of slightly strange position, that there are decisions in another case which are affecting the decision in this case. They've all been carried on in parallel at different times. So the reference...
Yes. Sorry, we've moved on from that paragraph we were looking at where the Court of Appeal overruled or came to a different view from Mr. Justice Henderson in FII, because we'll come back to this subject.
Yes, certainly, yes. I was going to come back to issue 3.
Well, I'll be able to put the question which puzzled me to you then.
Okay, yes. But I hope what I'll do is show you what Mr. Justice Henderson said about all of this in Prudential, which might make it clearer. So the reference was made, the second reference, which we're going to have to look at in a moment, was made by Mr. Justice Henderson at the end of December 2010. In February 2011, there was a judgment in Haribo. And that is obviously an important case in relation to issue 1. Haribo was a case which was entirely concerned with portfolio dividends. And it's in...
Sorry, that's... did not happen.
It's in Bundle 7 of the authorities, behind tab 63. Before we look at it, can I just summarise the position in Austria, which you need to understand this reference? The Austrian legislation at the commencement of proceedings provided for exemptions from corporation tax in 3 situations, broadly. One is domestic dividends, so it's obviously very similar to the UK system in that respect. Secondly, dividends from EEA countries, which had comprehensive procedures for mutual assistance with regards to administrative matters and enforcement, which becomes important, subject to an exception where the foreign company wasn't subject to equivalent tax to that in Austria, or it was 10% less than Austria, or it was exempt. So you had to look at the circumstances of the dividend-paying company in the state in which it was paying it to determine whether it was entitled to the exemption in Austria. And that's the second situation. And the third situation, dividends from shareholdings of at least 25%, which was then reduced retrospectively to 10% later, held for 1 year, subject to an exclusion to prevent evasion or avoidance, and to an exception where the foreign company is not subject again to equivalent tax as in Austria, or enjoys some kind of exemptions. So again, they had to demonstrate what the position was in the other country. And it was one of the aspects that caused the problem in Haribo, because it was being said by taxpayers, we're dealing with portfolio holdings, we've got very small shareholdings in these companies, we simply cannot find this information out. It's extremely difficult, if not impossible, to actually get the information and therefore to be entitled to the exemption. And we will see that the European Court essentially said that's part of the imputation system, essentially. Otherwise, so where it wasn't exempt, credit was given for actual tax paid abroad, except for dividends from companies established in non-member state parties to the EEA, if there was no comprehensive agreement, in which case you didn't get anything at all. In June 2008, there was an administrative notice, which has become quite important in this case, which provide for a simplified procedure for providing evidence of the foreign tax paid. And we'll look at that. We'll look at what it said about it in the judgment of the court. Haribo received dividends from portfolio holdings in companies established in both member states and non-member states, and they applied to the Austrian revenue for exemption from tax, presumably on the basis of European law as opposed to domestic law. And that was refused, and they appealed to the Austrian tribunals. The referring tribunal, which is the lowest tribunal, held that the dividends should be treated as exempt. So they essentially came up with the decision that Mr. Justice Henderson had come with. The Austrian authorities appealed to the administrative court, which allowed the appeal and held it was appropriate to apply not the exemption method, but the method consisting of crediting against Austrian tax the tax which was charged in the state of residence of the company paying the dividend. And you find all of this, what I've just been saying, between paragraphs 9 and 17 in the judgment report. The matter was referred back to the referring tribunal by the administrative court, which then referred questions to the European Court. And during that process, the European Court itself requested clarification from the Austrian courts as regarding the 2009 legislative amendments that I mentioned. Now, the questions which were asked are set out at paragraph 25 of the judgment. Sorry, I ought to have said what the administrative court seems to have done is applied a conforming interpretation, very much like the UK courts, to their own legislation. That is, they said that in conformity with European law, they would interpret it as granting a credit for the tax paid. That was, I think, the mechanism by which that was achieved. So the questions are at paragraph 25, and the decision of the court proper starts at paragraph 39, the answers to the questions. So the first question concerned dividends from EEA companies with no comprehensive agreement for mutual assistance. And the question there was it a legitimate condition that there should be such an agreement for mutual assistance? The first couple of pages of this, from paragraph 40 to 45, are not relevant. They're simply asking a question of admissibility of the question. And then the substance starts at paragraph 46. And essentially what the court concluded was that it was justifiable to have a requirement that there should be a comprehensive agreement in relation to administrative matters, because that was relevant in the imputation system to determining what the actual amounts of tax, etc., paid in the other state. But it wasn't legitimate to require that there be an agreement in relation to enforcement, because enforcement was not relevant to the imputation system. And you can see that if you turn on to page 2465, MS 2465, at the bottom, paragraph 74. and also paragraph 73, you can see the court's making the point that what is necessary, what might be necessary, is an agreement in relation to administrative matters, but not in relation to enforcement. So the answer to the question in paragraph 75 is that it wasn't permitted to have that condition. Then question 2. And what question 2? This was an important question because this concerned what was called the switchover from exemption to imputation system, where the taxpayer couldn't provide the information which the Austrian legislation required. And the taxpayer, and indeed the referring court, I think, were making the point that it was almost impossible to provide this information. You can see the requirement is set out at paragraph 79 on page 2467. Only where the recipient of the dividends has evidence relating to the level of tax to which the companies distributing such dividends are subject in the state in which they are resident. And it was held that that was a restriction in principle, paragraph 81, but that it was justified. And this was on the basis that it was legitimate to have both an imputation system and an exemption system following FII 1. And that's paragraphs 85, 86, 87 and 88. And then paragraph 89, in those circumstances, the imputation method enables dividends from non-resident companies to be accorded treatment equivalent to that accorded by the exemption method to dividends paid by resident companies. Application of the imputation method to dividends from non-resident companies makes it possible to ensure that foreign-sourced and nationally sourced portfolio dividends bear the same tax burden, in particular where the state from which the dividends come applies, in the context of a corporation tax, a lower tax rate than that applicable in the member state where the company receiving the dividends is established. In such a case, exempting dividends from non-resident companies would give taxpayers that have invested in foreign holdings an advantage compared with those having invested in domestic holdings. So what the court's saying, and they repeat this in a number of other cases, is that it's not required to give an exemption in these circumstances. What you do have to is you have to apply an imputation system of some sort, because giving an exemption goes too far. And then 90, in the light of the equivalence between the exemption and imputation methods, the difficulties the taxpayer might encounter in order to prove that the condition for the tax exemption of dividends received from non-resident companies are met are, in principle, irrelevant when determining whether Article 63 precludes legislation such as that at issue in the main proceedings. The only consequence of those difficulties, or even impossibility for the taxpayer, or even impossibility, he says, for the taxpayer to furnish the proof sought is that the imputation method, which is equivalent to the exemption method, will be applied to the dividends which the taxpayer receives from non-resident companies.
Have I got it correct now? The argument really centres on what is said in paragraph 89, or derives from that. The objection in paragraph 89 is that there is a risk that if you exempted non-resident company dividends, you would in fact be giving an advantage to taxpayers who receive them, because the non-resident company might in fact have paid tax at a lower tax rate.
Yes, than a domestic company.
Am I right? The debate has now moved on to the problem that in fact the domestic exemption, or the tax credit which recipients of dividends used to receive, which enabled them to claim cash in those days, operated or could operate at a higher rate than the company making the domestic dividend payments had actually paid. Is that right? You know, that it was pointed out that this problem also operated at a domestic level.
The problem of
the problem of a divergence between the amount of the benefit which was being given to the I think you'll have to take it through.
I think the point that's being made in paragraph 89, my lord, is simply that if you if you grant exemption to foreign dividends,
yes.
Then you might be
No,
an advantage because the foreign tax might be much lower than the Austrian tax that was charged on their subsidiaries. So you're getting an advantage to them. You don't have to go that far. What you have to do is give an imputation credit for the tax paid abroad, which means that the correct amount of credit is given.
But cannot that the question I'm really searching for is can an equivalent problem arise at a domestic level or not?
Yes.
It can do, can't it?
Yes.
Yes,
I mean, 89 is drafted on the assumption that in order to achieve equivalence, you have an imputation system abroad because the foreign company may have paid tax at a lower level than the domestic company paying a dividend to it.
Yes.
But the assumption must be that the domestic company paying the dividend is paying tax at the same rate as the recipient company, and this is the additional problem which emerges in FII 2.
Yes.
Yeah, that's really the point that So
yeah. Well,
we're being
so 89
yeah.
hasn't picked up differential within the recipient member state's country between the effective tax rate and the nominal tax rate.
no.
So
I think it's making a much simpler point, I think.
Yes.
Yeah. You might be receiving dividends from companies where there is no tax, or tax is charged at a very low rate, or whatever.
Yeah.
And therefore, you're giving an advantage to people who establish in those countries over those who establish in Austria
But
domestically.
the principle it's addressing is the achievement of the same tax burden or equivalence.
Yes, it won't be the same. It will be equivalent, yes. Yes, exactly. It's all about equivalence and trying to achieve equivalence, whatever that means. But it doesn't mean identical. It doesn't mean the same. That's important. Because everyone recognises you're not in the same position. If you invest in a foreign country, you're never going to be in the same position as you invest in your own country because the tax systems are different, just as a matter of tax.
All right, well, we move on at some
So that was the point. Then, what they were then dealing with in 90 was the switchover. That is, in order to qualify for exemption rather than imputation, you had to prove a lot of things which it was being said were impossible or very difficult to prove. And the court said that's not a problem. Even if they're impossible, you can still apply the imputation system. And then they go on to consider the administrative burdens. This is excessive administrative burdens imposed to qualify for the imputation method. And again, they say that the fact that compared with an exemption system, an imputation system opposes additional burdens is simply the way things are. It's not a difference in treatment. So the answer to the question was that different requirements for information didn't cause there to be a problem in EU law. In this section, there is a discussion of the imputation system, and paragraph 98 and 99 deals with that. So 98 says, whilst the company receiving dividends does not have all the information relating to the corporation tax that's been charged on the dividends distributed by a company established in another member state or a non-member party, such information is known at any event to the latter company. Accordingly, any difficulty that the recipient company may have in providing the information required relating to the tax paid by the company distributing dividends is connected not to the inherent complexity of the information, but to a possible lack of cooperation on the part of the company that has the information. As the Advocate General states in point 58, the inadequate flow of information to the investor is not a problem for which the member state concerned should have to answer. So that's an important principle that the European Court is setting down, which is it's not the problem of the member state that there is practical difficulties in getting the information. The information exists, it's simply, it may be very difficult to get it, but that's not a problem for the member state. That is simply inherent in the imputation system. If you grant a credit for tax paid, it's inherent in that the company claiming the credit has to prove what the tax paid was. And it's not good enough for them to say we can't find it out because they won't tell us. And that's essentially what Mr. Justice Henderson was relying on, you have seen in his judgment, where he was dealing with essentially the issues that are the cross appeal here on issue 4. He was dealing with the argument that if they're required to prove the tax paid, look, it's just not possible to do that. And his answer relying on this was, well, that's not a problem for the member state. And then we can see paragraph 99 refers to this simplified procedure. And this is quite important because a lot of reliance is placed on the fact that in Austria there was a simplified administrative procedure for determining, but importantly it was for determining the actual tax paid by the company making the distribution. So they say, furthermore, as the Austrian government observes, the notice of 13th June 2008 has simplified the evidence necessary in order to receive a credit for the foreign tax, in that when calculating the tax paid abroad, so this is all part of the process of calculating the tax paid abroad, account is taken of the following formula. The profit of the company distributing dividends must be multiplied by the nominal rate of corporation tax applicable in the state in which that company is established, and by the holding of the recipient company in the capital of the company distributing dividends. Such a calculation requires only limited cooperation on the part of the company distributing dividends or of the investment fund when the holding concerned is possessed through such a fund. So that's the reference to that. And there is earlier on in the judgment, you can see it, page 2443, in the recitation of the facts, paragraph 7, there is a more detailed description of this procedure. Of the notice. And it's particularly important to look at the third bullet point. This is what you have to provide, a precise indication of the rate of corporation tax to which the company making the distribution is subject in the state in which it is established. If it is not subject to the normal tax regime of the state which is established, in that, for example, it's a benefit of more favourable tax rate, a personal tax exemption or significant tax exemptions or reductions, the rate of tax actually applicable must be given. So what's clear about this system, even whatever significance you think it had, was it did require the Austrian company to provide the information as to the actual tax rate. The tax rate is actually applied to the company making the distribution, the foreign company.
So what's said in paragraph 99 is actually a simplification of the scheme as described in paragraph 7.
Yes, exactly. But it doesn't make this point. And
well, it is still purporting to, in paragraph 99, to be calculating the tax paid abroad.
Yes, yeah. So what you've got to show under this system, for instance, is that they're actually paying tax at that rate. In other words, that their income is not all exempt, for instance, or they've not got some special tax regime or anything like that. It's not saying you can simply take the headline rate of tax in the country and apply that, which is the approach that's been taken in this case. The second point to make about this simplification is that it doesn't play any part in my submission in the decision or the reasoning of the court. It is noted as being something that is there, but the court doesn't say in any way that the legislation in Austria is only compatible with the treaty because of this simplification measure. When we look at 104, this is the answer. The answer to the second question referred, therefore, is that Article 63 must be interpreted as not precluding legislation of a member state under which portfolio dividends, which a resident company receives from another resident company, are exempt from corporation tax, whilst portfolio dividends, which a resident company receives from a company established in another member state, are subject to tax, provided, however, that the tax paid in the state in which the last mentioned company is resident is credited against the tax payable in the member state of the recipient company, and the administrative burdens imposed on the recipient company in order to qualify for such a credit are not excessive. Information demanded by the National Tax Authority from the company receiving dividends that relates to the tax that has actually been charged on the profits of the company distributing dividends in the state in which the latter is resident is an intrinsic part of the very operation of the imputation method and cannot be regarded as an excessive administrative burden. So we would submit the answer is quite clear. First of all, it's enough that you grant credit for tax paid and that it is perfectly legitimate to ask the company to prove what that tax was. Question 3 concerned the situation in which no tax credit was given at all in Austria. And in paragraph 138, the answer was, I think not unexpectedly, that Article 63 precluded legislation which exempted portfolio dividends, but for dividends distributed by a company established in a non-member state, provided neither exemption nor a system which a credit is granted for the tax the company paid in the state in which it was resident. So there was no credit or no exemption at all. And then question 4 concerned what I would call the conforming interpretation which was made by the Austrian courts. So if you look at the 4th question, the referring tribunal seeks in essence to ascertain whether Article 63 precludes a national authority from applying the imputation method in the case of portfolio dividends from companies established in a non-member state party to the EEA agreement, which the Republic of Austria has not concluded a comprehensive agreement with regard to administrative matters, despite the fact that that method results in an allegedly excessive administrative burden for the recipient of the dividends, on the ground that application of that method, according to the decision of the administrative court in Austria, comes closest to the will of the legislature when inapplicability of the 10% threshold would give rise to tax exemption and therefore automatically prevents economic double taxation for portfolio dividends from companies established in non-member states. So they're asking whether, in a situation in which the court has, if you like, there wasn't this system in the black letter law, but the court has interpreted the law as providing you with this credit, whether that is legitimate, despite the fact that there is an alleged excessive administrative burden on those who receive the dividends in proving what the foreign tax was. And the answer to that question is the same as the answer to the previous questions. They say at paragraph 144, the allegedly excessive administrative burden that application of the imputation method involves has already been examined in paragraphs 92 to 99 and 104 of the present judgment. And then the answer to the 4th question, Article 63 does not preclude the practice of a national tax authority, which for dividends from certain non-member states applies the imputation method, where the holding of the recipient company and the capital of the company making the distribution is below a certain threshold, and the exemption method above that threshold, whilst it systematically applies the exemption method to nationally sourced dividends. So that's exactly, we would say, the system that we are arguing for, provided, however, that the mechanisms in question designed to prevent or mitigate distributed profits being liable to a series of charges lead to equivalent results. The fact that the National Tax Authority demands information from the company receiving dividends relating to the tax that has actually been charged on the profits of the company distributing them in the non-member state in which the latter is resident is an intrinsic part of the very operation of the imputation method, and does not affect as such the equivalence between the exemption and imputation methods. So that answers the point, if it was to be made, that it's all very well saying that you can impose administrative burdens if the legislation provides for it, but not in a situation where it's a conforming interpretation being adopted by the court, which is what we have in this country, in this case. And the answer to that is it's exactly the same, whether it's the law as written or it's a conforming interpretation. The position on administrative burden is exactly the same. It's also important to notice, we say significant, that this case, which was also decided, you'll see Judge Lenart's, who is the rapporteur in this case, features heavily in many of these cases, including the second reference. It's significant to note, despite the fact he was involved in both this case and the reference in the present case, and FII number 2, that there's no hint in this case, which concerns portfolio dividends, with the idea that the foreign nominal rate might be a relevant factor. Right. We only find that when we come to FII number 2, which is the case I was just going to turn to.
Well, would that be a convenient moment?
It would. Well,
how are you doing in terms of your submissions?
Heaven knows. I think once we've cleared the ground with this, we can deal with the submissions reasonably briefly after that. I will have to look at Sempra, I'm afraid.
2 o'clock.